Hi everybody, I'm immigration lawyer John Khosravi. Thank you so much for joining us again for another one of our live sessions. Today is October 27th. Oh my God, October is going to end. Life flies by. November is going to be coming. And then before you know it, Thanksgiving, Christmas, New Year, and we're back at it at a new year. I want to remind everybody that we're going to be talking about U.S. immigration law, but it's general immigration law kind of stuff. I actually forgot to add TikTok to the mix because we're live on Facebook, YouTube, LinkedIn. My wonderful assistant Katrina all of a sudden said, hey, we're not on TikTok. So I'm going to be setting that up and we're going to take your questions live about U.S. immigration. It's all educational kind of stuff. You really need to talk with an immigration attorney in private about your own case to see what's going on. There's just so many wild different things that pop up in U.S. immigration that unless you see the documents, unless you talk with the clients and see the paperwork, it's hard to really get into it. But we do our best and we'll try to answer them here. A couple of reminders. We have a new show that's starting with my associate, Anya Sergiva. We record the first one, should be out pretty soon. Just having longer form context about certain issues that are really important for the immigrant community with regards to U.S. immigration in particular. And another thing is we give out free consultations on the live session. So if you're watching this and you're interested, and you want to talk with me, usually there's a fee and we have to set up a time, all this kind of stuff. But for those watching on the live show, we give out 3 video consultations for free every 10 minutes. So what you have to do is click like and subscribe to wherever you're watching, and then write consultation in the comments. My wonderful assistant Katrina will name a person at 6:10, 6:20, and at 6:30, and I'll name you off and give you instructions on how to schedule the time. The last thing I want to say before we start is if you're interested in a family-based case, a marriage case, for example, for a green card, download the Ultimate Marriage Green Card Guide. It's at marriageimmigrationlaw.com, marriageimmigrationlaw.com. It's a strategy guide that really breaks down the process for you. It's the best thing out there. Download it. If you're even somewhat interested, look at what I did for you there. You're really going to enjoy it. I put a lot of time into it. We're going to be updating it soon, but it really gives you a heads up on what's going on the forms that are used, what issues exist, how the process works, and there's links to my long form videos about each one. Those videos even breaking down further. I've had dozens of people contact me or even on the live show say they just use that in my videos to really put together their own case. I'm happy with that. The key is to help people enrich their lives and reunite with their loved ones. So either way, but if you wanted to schedule a consultation with me, just email me at info@jqqlaw. We can do a one-on-one consultation. If not, watch the videos, read the ebook to get a better understanding of what's going on. And with that, let's get it started. If I have an expedited approval set to the embassy and I've not heard from them in a month, what should I do to the embassy in Port-au-Prince, Haiti? Well, try emailing them again and seeing, is there anything I could do? I can't get my appointment. So you just got to email them. Every embassy has different procedures on how they, do registration for appointments. Usually they'll schedule it themselves. You'll get an email from the National Visa Center. But if you get an approved expedite, the embassy will email you themselves. But you just got to communicate with them, either email them directly, go through their website, see what kind of stuff they have. Some embassies, like in China, although I have their email address, if I email them, they won't respond to me. What they do is they have to go to their special page of theirs and then through that submit my request. So it's a weird situation, but contact them. Or, if you contact this happening, you contact your local congressperson after the embassy is not responding. Ask them to get involved, maybe your senator, and say, this situation, please help me, and see what they could do. Now, the embassy in Haiti in particular is not doing too good. A lot of, just like unfortunately the country with the earthquakes and the recent assassination, it's semi-shutdown mode, and it's not just Haiti, it's most of the world with COVID and everything. But just stay on top of them, communicate with them, and kind of keep pushing it. It is what it is. You gotta take care of yourself and do what you gotta do for your case to move forward. But it's a mess. We have a lot of people recently who watched the show have cases in Haiti, and they all said the case is stuck, it's not moving forward. So I haven't heard of any good news about the case moving forward, but that's what's going on right now. 29 Super C1 regular says, hi, good night, Attorney Khosravi. Did you watch yesterday with the Charlie Oppenheim on November Bulletin? If so, what's your thoughts on the EB3 visa category for India and China? I didn't watch. So what happens is the person who really sets the visa bulletin, this is how long it takes for people to get their visa interview, especially if they're doing consular processing. It's the thing called the Visa Bulletin by the Department of State. And Charlie Oppenheim's the end guy who makes the decision on this kind of stuff. I watched one or two of his videos. I didn't get anything out of it, so I just stopped watching it. Maybe there's stuff that could be gotten in future ones, but it just didn't do anything, so I don't watch that. Now, with regards to EB3, employment-based third category, for unskilled workers and a couple other subcategories, you know, we thought they were going to jump forward. They didn't. A lot of the people who did something called I-140 downgrades are getting really hurt because there's retrogression in EB3 category. My thoughts are, you know, we have no idea what's going on. I don't think they know what's going on. Everything is a mess. And it just gets worse and worse and made it more difficult for people. But no good news. But I didn't watch the show, his show. Maybe he said something that was helpful. But I doubted the way things are going. It would have come back to me by now or by tomorrow if there's any news. So I'll let you know next week. But employment-based categories, just all the preference categories, or if you're doing consular processing, it's a mess. The only bright side is if you're already in the United States, for example, working on a work visa H-1B or something like that, USCIS said that you could start your green card process sooner by using the date of filing chart as opposed to the final action chart. This means that even though your green card is not ready, you can still submit the paperwork, apply for a work permit, apply for child permission, advance parole. And along with that, a thing called portability comes into place, where once you submit your adjustment of status from I-485 application and it's been pending 6 months, you know, I don't do these cases often. I-140 I think has to be approved before that, but let's say the I-140 is approved and your I-485 is pending. After 6 months, you can do portability and change your job to the same or similar position somewhere else. Even be self-employed, start your own company, but it has to be in the same or similar position. There's a lot of nuance that we have to review your case individually to see what's going on, but that's something that's really helpful USCIS did. So that's the bright side of all of this. But 29 Super C, thanks for watching again. I hope to hear good news in your case and hear that you're in the US. Dadu asks, can I adopt my 1-year-old niece in Haiti? So, I don't handle immigration adoption, but typically there's a thing called the Hague Convention. First of all, you have to see if Haiti is a member of the Hague Convention on adoption and see what the rules are. But again, typically, if the child has parents alive, it's very difficult to adopt them. But adoption is a really complex thing, depends on the country they're from and a lot of other factors. So I would recommend consulting with an immigration attorney that does adoption immigration and really breaking things down to see what's appropriate there. But I wouldn't want to advise further on that here or talk about it without knowing a lot of details, and it's just not my specialty. So thanks for the question, but I wouldn't be able to help you further on that. The Grace 1991 asks, if you're married to a US citizen but haven't started the green card process at all, will it still be difficult to get a B1 visa from my home country? So it will be. It's not guaranteed I'll be bad, but there's a lot of factors. So let's back it up. A B1 is a business tourist visitor. A B2 is a visitor for pleasure. So let's just assume you want a B2, not a B1. Or just a B in general is when you come temporarily to the United States for some purposes of leisure or just basic meetings, not to work, but to just do some basic business. And that definition is very vague, and I'm not going to go into more here. There's this presumption that's written into the regulations that says everybody who wants to come to the United States is actually coming here to stay, not go back home. So initially everyone's looked at as guilty until proven innocent. And that's why there's a high denial rate, especially for some countries in particular, for the B visa. Now, if you're married to a US citizen, once you enter the United States, you could, for all intents and purposes, apply for a green card pretty quickly and just stay here. And they know that. So they're very hesitant in approving these visas if you're married to a US citizen. Having said that, I see these cases approved all the time. So it depends on your personal background, on the reason you want to come to the United States, what ties you have to the home country that you're living abroad at. Do you have a home there? Do you have work there? Do you have other family members there? Like if you have 5 kids, are you going to just be coming, your 5 kids staying at home? They'll assume that you want to go back to your kids, so it might help you. And frankly, it depends on which country you're from. So some countries have massively high denial rates for B2 visas or B1 or B visas in general. Others don't, and they're more trusting at the embassy. So there are just so many factors. In general, it's going to be difficult, but it's up to you. The key thing in these applications is you have to pay money, give it a shot. If it works, if it doesn't. In most countries in the world, getting a tourist visa or B visa interview is almost impossible because they're not scheduling them due to COVID and the shutdowns. But the only thing as an immigration attorney when people are asking about tourist visas is please take time to review the form DS-160. That's the application form for a B visa, and frankly for every non-immigrant visa. And fill it out properly, review it, and make sure there's no mistakes, because mistakes can come back and bite you later on. I've seen this before. People, not mention work history or residential history or marriage or divorce records or children in the DS-160, and then later on, years later, they're applying for another visa category or green card, and inconsistencies pop up, and because of that, they may deny you or accuse you of fraud or misrepresentation. So, is it any difficult to get the B? Yeah. Is it worth a try? Well, it's up to you how much time, money you want to spend on it. My throat, I'm yelling right now. I need to calm it down a little bit. Yeah, I get excited to talk about immigration. I can't help it. I answer the same questions every day, all day, but it just doesn't get tiring. So it's a wonderful, wonderful job to have. But my main thing in these kind of cases is your DS-160 filled out properly so you won't have issues later. So that's my best advice I give you, is focusing on DS-160. But it's up to you if you wanna apply or not. So I wish you the best, and hopefully you get a quick vacation in the U.S. YH asks, hello sir, I filed my online I-130 petition. My parents is a U.S. citizen applying for his parents. Is it okay to upload the family pictures that show me and both my parents? I heard USCIS may want to see more evidence to prove father's case. No, it's not really good to upload documents. You could do that, but it's just send USCIS documents while the case is pending unless they ask for it. Sometimes they don't get it and stuff. But, for a petition for a parent, pictures don't do anything. What they want to see is your birth certificate listing your parents. And listing their names so you could attach it to them. So there's a couple issues that pop up right there. One is if your parents, if you're applying for your mom, you just need the birth certificate to show your mom is your mom. If you're applying for your dad, not only do they require a birth certificate, but they also require a marriage certificate between your parents. If your parents were not married, then you have to add more evidence to show your father was in your life and supporting you. Photos are partially helpful, but a lot of times they want to see, material stuff, financial support. You're listed on school records and that kind of stuff. So I don't know, your parents, I'm assuming, are probably married, so you don't need to go into that. The second thing I wanted to talk about, and I had a discussion with my associate Anya about this, you're going to see a video about this soon, is your birth certificate correct? Is it have their names properly spelled on it? Is it issued soon after your birth? Or were you born and then 10 years later they registered your birth certificate? Because all of a sudden, if you have a 10-year gap from birth to birth certificate registration, they may assume that the birth certificate may be fraud or not acceptable. So there's second and third level issues I see as an immigration attorney in these kind of cases. And so that's what I wonder of. But to add photos and stuff, don't waste their time or cause confusion for USCIS. If you filled out your I-130 correctly, the marriage certificate for your parents with translation if needed, and your birth certificate with translation if needed, then that's something that you could look into. To add, or you should have added at the beginning of filing. It's in the instructions, but just keep an eye up. Overall, that's it. I wouldn't go and add photos yet. I don't think it's necessary unless other issues exist where you need to prove your family relationship with your father. 29 Servici follows up. The Department of State still hasn't updated its monthly immigration status on its website. The latest date is still July 21st, and since August 21st, yeah. These statistics that they're providing on the immigration status, they update how much cases are in backlog. This is a new thing that they started, which is nice, but there's always a delay in it. That's just baked into the cake when you're dealing with the immigration department. That's why, we have a lot of cases right now that are just pending. They're not going anywhere. This is just a norm. We've seen this kind of stuff. So you just got to expect it. I know it's hard when you're separated from your family or your job, all this kind of stuff. But fortunately, that's how it goes. But thank you, 29 Servici. We'll take the next question. Douglas asks, hi, I lost my F1, but I'm staying in the United States because I have babies and they're born right here. Did you opportunity about my situation? I'm not clear what your question is. An F1 is a student visa. It's also a first preference family category, but let's assume it's a student visa and you may have overstayed, but you have kids here. What do you do? Well, if your kids are 21 and you enter lawfully and don't have a bunch of other issues or something like that, you potentially, apply for a green card. I don't know. You say you have a social security number, okay. But if you have kids, if you have a relationship with their mother, you could try getting, and you want to get married, maybe you can apply for a green card. But there's just too much going on. It's not something, I can't give individual legal guidance here. You need to talk with an immigration attorney in private about your case to see what's going on. it's just not an appropriate place here to go into that much detail in your case. Tony Mario, one of our regulars. Hi John, it's a pleasure listening to you as always. Is there anything I should do while I'm waiting on a transfer of my I-824 approval from USCIS to NVC? If no, does NVC email me for what's next? Thank you in advance. So the NVC, the National Visa Center, is supposed to contact you when they have the file, and I-824 is requesting that USCIS send your file to the National Visa Center to do consular processing. What you guys have to do is, if it's taking a long time, like, you know, you got the I-824 approval, it's been 1 month, maybe 2 months, contact USCIS to see what's going on, contact the National Visa Center to what's going on, and just make noise. And every month do that. 2 or 3 months of contacting them, nothing moves forward on the I-824, National Visa Center is not contacting you, then contact your local senator and ask them, hey, what's going on? We got the I-824 approval. They should be moving forward. It's not. Someone's falling asleep at the wheel. And just push the issue. I've seen them fall asleep at this wheel for the I-824. For some reason, this form has complications, but you just got to keep following up to make sure they're moving things forward if they're delaying it a lot. Iki asks, can you apply for a tourist visa for someone who's going to take an exam as an international medical graduate? It's not you apply for them, they apply for themselves, and it is possible generally to apply for a tourist visa to give certain exams in the United States. You let them know and you come. With regards to medical students, there's some specific training and test taking that you can apply for a tourist visa. It's in the regulation for that. But yeah, you could come to take certain exams. The embassy officer who reviews the case is still going to look to see whether they think you're actually going to go and stay in the United States or if you're going to leave. And so they might get denied. But it is possible to come to the United States to do certain exams. That's an accepted thing. But you know, you just can't work. Employment authorization does not come with most B2 visas. So it's got to be just to give the exam. And be prepared for the person to talk about that so they know it's real and not just making up something about an exam just to come to the United States. But thank you for your question. Do I need an I-131 with my I-485? That's advanced parole travel permission with the adjustment of status from I-485. If I have a valid H-1B visa, if yes, can I exit when I-131 is pending? So I have a policy of almost always filing for advanced parole form I-131 with my I-485 just to do it. You never know. You might lose your H-1B, you might be fired, then all of a sudden you need to travel, you don't have travel permission. So there's no additional filing fee for it, so I don't see a reason not to do it. Now, if you do travel while the I-131 is pending, there is a realistic possibility, it will void the I-131 case, but you know, you have your H-1B in that case, so it doesn't matter per se. But it's better to have it than to not to have it. And if you do leave, let's say you have your advanced parole approved and you have H-1B and you leave, you just got to make sure to re-enter with your H-1B just so you keep the H-1B alive. Sometimes they'll mistakenly give you advanced parole. Don't just show them the H-1B visa, come back in. Now, if you travel, there's other issues that could pop up, so I can't give unique individual advice on this. 29 Super C follows up, hi, Attorney Khosravi. In my country, if one wants a B1, B2 visitor visa renewal, they can mail their documents, e.g. DS-160, pass or payment, to the embassy approval. Yeah, so if you already have an approved B1, B2 in the past and you're going to renew it, historically, to avoid having the complication of going inside to do an interview, all this stuff, they would renew these visas by paper. So you submit a DS-160 online and you mail them your passport and the like. After Trump came, he said that everyone has to do an interview. They took away this automatic renewal, non-interview based renewal, and they canceled that, which slammed the embassy system because all of a sudden there's hundreds of thousands of B1, B2 visa interviews they have to do. And then travel bans came and COVID came and just messed up the system. They're bringing it back to do renewals of non-immigrant visas. Not everyone is participating, not every embassy. Doesn't mean it's faster now because of all the issues, but it's more and more happening where they'll do renewals by kind of mail, so not have you come in for an interview if they so choose. So the algorithm in their computers makes a decision whether you have to come for an interview or not, and it's possible that they'll approve it. So it may work. The system's such a mess and things have changed so much from the previous administration to now, plus adding the pandemic, that it's not guaranteed that you could renew your B1, B2 visa through by paper. So it's possible they'll still want to see you in person, and every case is different. Even if this was still the rule that they would permit paper-based renewals not coming for interview, it wasn't 100% of the time. But thank you for your question. Jewel asks, I missed my biometrics appointment today with my son. What did you suggest me, please? Okay, so what I suggest, contact USCIS, let them know it's missed. Before 2 months ago, if you missed a biometrics appointment, they would just automatically reschedule one a month or two later. But 2 months ago, they changed the rules and said they may cancel and deny your case if you missed the biometrics appointment. It's really harsh. I can't believe they said that. But it's not necessary that they will actually do that. But call USCIS on the 1-800 number, let them know about what happened and the reason why you missed it, if it's a good reason, and request rescheduling and see what happens. Sometimes you could take the biometrics notice you had and just take it in, it's too late now, but go tomorrow to the location and ask them if they could just do, just random walk-in. They used to be able to do that. A lot of them are not doing that now, especially because of COVID, but give it a shot. Call USCIS, go in person to the biometrics, the AESC, and see, maybe you can pull it off and do that. So give it a shot. A quick note, I want to remind people watching this that one is we have these free video consultations, 15-minute we give away. We have one more left at the end of the show. We'll announce. To take part, you just like and subscribe where you're watching this, and you write consultation. My wonderful assistant Katrina will name someone off. Secondly, if you're interested in a family kind of marriage-based green card case, download the Ultimate Marriage Green Card Guide at marriageimmigrationlaw.com. The best ebook out there on the topic. It's free. It's really going to break down in a quick way what's going on, so you have an understanding of what all of this entails. The U.S. immigration system is as complex as it gets, and so hopefully this ebook will help you out. I think it will. Can't find joint sponsorship. Can I show cash? I have my own business. Well, let's talk about what joint sponsorship is. So if you're going to do a family-based case and some employment-based cases, but we'll just focus on family-based cases, the U.S. petitioner has to be able to show they make enough money to support the foreign person getting a green card. If they don't make enough money, typically we want a joint sponsor, another U.S. citizen or green card holder that could jump in and show they make enough money. Now, in this case, the person can't find a joint sponsor. Using assets is possible. It's in the regulations. Cash or things that could turn into cash, become liquid within 1 year, but they have a really high standard. So if your case is going through consular processing, through the embassy system, I do not accept cases where we use assets, even though it's in the regulations, because I've just seen this too many times where embassy officers will not accept it, and I would not want to risk a case on that. I would say get a joint sponsor. Now you could still try it and they won't necessarily deny your case outright. They'll give you time to get a joint sponsor, but I'm just pessimistic on the consular processing system accepting assets. But if you're in the United States for adjustment of status, I typically do, not typically, but I do have used cash and assets like that, but there's requirements. So, and it's a lot. So for example, let's say you have a car and you want to use the value of your car as the asset to show you have enough money. You can't use your first car because you need that to make a living. So you have to have two cars, and the second car be the automobile that you base the cash on. But then you have to get breakdowns of how much your car is worth and kind of like appraisals. Or if you have your own home, you have to get appraisal for the home. So it's a lot of headaches and makes it complicated. If you have cash, which is typically what people use in this kind of case, you have to show a complex formula, which it's too complex for me to get here. You got to schedule a private consultation to go over it. But either 3 to 5 times the amount required for your family size on Form I-864P. And you have to show you have that amount. So let's say you're single or you're married, so it's family size of 2 in this case, the spouse being the foreign immigrant who's coming to the United States. The amount you have to make as income on that one is around $23,000. Let's round up to $25,000. It's not correct number, but just for math's sake, say $25,000. If you're a U.S. citizen applying for your spouse, and using assets, you could show a multiple of 3 times that, so 25,000 is 75,000, and in that case, you will show that you have enough assets, cash on hand, to be able to support that person and do it. Now, you can't just put 75,000 in your account right now and show it. You have to show that you have that amount on average over the last 12 months in your account. So you can get a statement from your bank saying the average balance in that account over the last 12 months has been above that amount. Or you could get 12 months worth of bank statements, add them up, divided by 12 to show what the average is. So maybe 11, 12 months ago, you had $1,000 in the account, but right now you have $200,000 account. You kind of balance it out to see if the amount is above the required amount. The number I gave, 75,000, is not exact, and it varies depending on what kind of case it is. So that was just an example, but it doesn't match every case. It gets really complex, and these are the kind of things you definitely need to have an attorney when there's affidavit support issues, because it's just always a fight on this kind of stuff. But it's possible. But we got to see your taxes, we got to see a lot of stuff. It's more complex than just saying I have my business and I can show cash. There's a lot of paperwork and analysis that has to happen. Jordan, one of our regulars, hi, is it a problem if I apply for a green card on a non-immigrant visa, for example, a J1 or F1? Not per se. I can't say in your case because I don't know your background, but I follow these cases J1, F1, B1, H1B, L1, adjustment of status all the time. They're just other factors you have to look into it. For example, on the J1, are you subject to the 2-year home residency requirement? Or for an F1, or for did you fall out of status and are you marrying a green card holder? Because that would be a problem. So it is possible, but there's just more information I would need. So I can't really answer that question properly because I need to know all the facts. So definitely schedule a private consultation. We can get into that, Jordan. Thanks so much for your question. Anastasia asks, can an F4 category be expedited for kids over 21? You can't expedite the visa bulletin. So F4 is a brother and sister of a U.S. citizen. It seems like the niece or nephews might age out, become a problem. There's one thing, there's a Child Status Protection Act which could potentially save them. But secondly, you can't expedite the visa bulletin, so that's just not happening. There's some nuanced stuff. If you're able to get humanitarian parole and come in and, you know, it may or may not work, probably won't. So, you know, you gotta schedule a private consultation to review the details because I gotta see your I-130, I gotta see the ages of the children, all this kind of stuff. But the basic question of whether you can expedite a preference category case itself, no, you can't because those are fixed timelines. You have to wait your turn on the visa bulletin. Thank you everyone for joining. You know, things are moving forward a little bit, so things are bright. And getting brighter, let's say, not bright, but things are getting better. But thank you everyone for watching. We'll catch up with you again next Wednesday. And check out the new show I have with my wonderful associate, Anya Sergieva, popping up, probably come up next, you know, Thursday, Friday, Saturday, something like that. You're going to have a lot of fun, a lot of information that's going to be very helpful for a lot of people. Until then, God bless, be safe. Talk soon. Bye-bye. I hope you enjoyed this educational video. You'll find our social media site has a lot more videos, images, and information about the U.S. immigration process. Please check those out on the various social media websites.